You're hurt at work. Doesn't your employer owe you at least a reasonable roadmap through the workers' compensation system?
This is the American Law Journal. Made possible in part by Beatty, Sloan, and DeGenova. Decades of experience providing personal attention to personal injury. Chartwell Law Offices, representing companies in comp and other business matters. The law offices of Anthony Vellner, providing counsel for injured workers for more than 15 years. And The Legal Intelligencer, the nation's oldest legal newspaper for lawyers.
Nothing, it seems, sours the relationship between the boss and the employee more than a work injury, but with a comp system designed to sidestep lawsuits, and especially if insurance is already in place, why the bad blood? Hello, I'm Christopher Naughton, and welcome to the American Law Journal. Good to be back on the Comcast network. Good to be here at the Union League in Philadelphia, Pennsylvania. Good to have my four guests with me today as we discuss workers' compensation and that very delicate relationship between the employer and the employee, especially if a work injury has taken place. George Beatty joins us once again, returning to the set with Beatty, Sloan, and DeGenova. For over 25 years now, George has zealously represented those injured at work in personal injury matters and medical malpractice. Andy Greenberg joins us this evening, representing the corporations, the third-party entities, and the carriers when it comes to workers' compensation. Tony Vellner, 16 plus years in practice, representing claimants in workers' compensation and Social Security disability matters. And the Honorable Joseph Haken, who has graced our set in the past. New setting, Judge, but it's always good to have you here. Short trip for you from Malvern, Pennsylvania, relatively
nice
so.
to be here.
We want to remind you, if you need more information once we leave the air today, it's easy. Go to our website, lawjournaltv.com or americanlawjournaltv.com. Every program that we produce here later goes up to the website as a webcast. If you need the name of an attorney or want to find out more information in about 24 different areas of law, call us toll-free, 888-78-LAW-TV. Write to us at info@lawjournaltv.com. Go to the website and get your law on demand. 100 years ago, roughly, they started this workers' compensation system designed to take some of the anger and the rancor out of the tension between the employer and the employee. In a system designed to take the rancor out, why is it sometimes that employers and employees, once someone gets injured at the workplace, go to their opposite corners and begin a fight, even before a lawsuit is filed? Why is that, Andy?
I think from an employer standpoint, sometimes the work injury isn't the beginning of the problem. Sometimes the work injury is the culmination of the problem. You have an employee who has attendance issues. You have an employee who is not performing the job well. You have an employee who doesn't get along with a coworker or a supervisor. And sometimes the employer feels that the allegation that an injury occurred is just the final straw that's breaking the employment-employee relationship back, so to speak. So
maybe there's almost a slight inference that, you know, this relationship has been breaking down, and then maybe something minor turns into something major.
Yeah, I think that's oftentimes the case from my standpoint, that like I said, the work injury isn't the beginning of the story. It really is more the end of a long or short, difficult story.
Tony,
I'm not surprised to see Andy have that viewpoint. I'm not at all surprised, because from my perspective, which is the exact opposite of Andy's, often I see the work injury as being the beginning of the deterioration of the relationship. I've had clients that have been employed for many years by employers, have been loyal, solid, good, hard-working employees, and when they suffer a work injury, there's this natural tendency on the part of the employer to think, oh, they're going to try to get money from our insurance company. Heaven no. So even though this person was legitimately injured, all of a sudden there were attendance issues. Aha, never mentioned before. There were disciplinary issues, never mentioned before. So Andy's on the phone with the employer saying, did the person ever give a dirty look to somebody? Did they do this or do that? They start this black book develops that didn't exist before. So I think
and
to
really
answer,
has nothing to do
Nothing.
with the case in chief, with the workers' compensation.
Nothing to do with it, but it's human nature, I think, Chris. When you look at a situation, you're an employer, paranoid. There's a lot of propaganda out in the media today about lawsuits and abuse and frivolous this and frivolous that, because the insurance industry spends billions to influence public opinion like this. So there's a tendency, if you're an employer, and John got hurt and he broke his arm and it's a fracture and the x-ray shows the line, well, there's a tendency, even if it's that clear, to say, well, wait a minute, now he wants money. Well, the system is designed to protect families from financial ruin when the breadwinner is injured.
And really, Tony, when it gets right down to it, it's not as if the employer, 99 times out of 100, is going to be really losing anything. Yeah, his insurance rates may go up a little bit.
From our angle, representing injured workers, I don't understand it either. I look at it from an angle that the employers fall back into this defensive mode of, like George said, hey, this injured worker just wants something. How's that going to affect my other employees? Now they're going to, oh, maybe I got an injury too. Like any relationship, I think when now an injury is involved, there's a breakdown of communication. Most new clients I see, they come to me or George Beatty because the employer's not talking to them. They haven't heard from the comp carrier. The employer is telling them they don't know what to do with them, and it becomes a big, everybody gets into their foxholes.
You represent the carriers as well. In fact, primarily, as long as an employer is insured, the employer's really not going to be losing anything. His rates may go up a little bit, but his ox is not being gored. No one's sticking their hand inside the employer's pocket. Do you think that employers overreact sometimes when they really have nothing to lose?
Well, it's certainly a oversimplification to suggest that the employer has nothing to lose.
What do they have to lose,
Well,
Andy?
insurance arrangements are very different. I mean, some insurance arrangements are such that the employer is responsible for a very large deductible or a front-end retention, so the employer is paying for it.
All right.
Oftentimes, employers, many of whom I represent, are self-insured. You know, it's funny. I've had an opportunity to represent two companies. One that I found the situation very interesting. One was a doctor who's a well-known plaintiff's doctor in the area, and one was a well-known workers' compensation claimants firm who had employees claiming work injuries. I found it very interesting, the reaction in those situations to these claims. The reaction was the same kind of reaction you oftentimes get with employers who have nothing to do with the workers' compensation system. I found that very interesting. You know, an employer has a lot to lose in terms of just operating the business. This law firm was very upset because the person who supposedly had gotten hurt was responsible for payroll and personnel, and this person was out of work. It was causing significant disruption in this claimant's attorney's business. So even though he wasn't paying the benefit out of his pocket, or at least on a direct basis, it was interfering with his ability to manage his business and to operate his business.
And people tend to take that somewhat personally.
I think that's the most legitimate remark, from Andy's side of the aisle, because it's true. If there's a small business and a person who's critically important to that business is out with a work injury, that is an impediment to getting the job done. And I think, unfortunately, when there's a problem with the relationship, when people start saying, ooh, attendance records, ooh, discipline, that then it chills the communication that happens between employer and injured employee, because you'd like to be able to pick up the phone and say, hey, Kathy, I know you're hurt, but could you tell me where you file the checks for such and such? And then there's a little bit of a thawing of this tension that exists, and I think you'd be better off. But unfortunately, human nature being as it is, it's not always like that. And it's our job to protect our clients as employees, to do what's necessary to make sure that they don't get taken advantage of. That's my job.
And there's certain things that can happen that an employee can do that can cause a provocative response from an employer. If an employee one day, after a seemingly minor work incident, suddenly retains counsel who makes a call to the employer, that is a provocative action that's going to elicit perhaps a provocative response.
In other words, why didn't you just work with us in-house? We could have taken care of it. We would have taken care of you. Now the gloves are off.
I agree with Andy there. And what I do in a lot of my cases, a person will call me right after an injury and say, what do I do? What about this? What about that? They have legitimate concerns, legitimate reasons to consult a lawyer. They should call a lawyer right away. It's important to know your rights. It's important to know what's going on. But I take a little different tack than some other lawyers. I don't want to jump in there, cause trouble. I say, wait a minute, how long have you worked there? Ask me the questions. I'll give you some information from behind the scenes. Let's see how this develops. I'll be in the background. If necessary, then I'll come out there and do what I need to do. But some lawyers are bulls in china shops. They want to run in, send a letter out, solidify the situation, and that's not always good for the employee.
File first and ask questions later.
Right.
Judge.
I think that what the attorneys have been indicated here is they're true, everything you're saying, both sides. there's a semblance of truth involved in it. My own experience in this matter, of course, we only see the case when it gets to litigation. It may occur more so, this disruptive attitude in the minor cases. I think when you have a really serious case, everyone can recognize that this is a work injury, the employee has to be taken care of, compensation has to be paid. I think there's maybe the tendency sometime on minor injuries that the employer may well say, gee, the person should have been back to work within a week, how come it's taking more time, now he wants to see another doctor. It's that type of thing that occurs. I do think that what Andy indicated, however, that many times this is just the end result of something that has been going on for a long time, and it just exacerbates the situation.
Andy, question, true or false, in your experience, employers do not give workers enough information to at least be knowledgeable of the workers' compensation system. They would almost prefer that they be a little bit more ignorant than informed.
I think it depends on the industry. I mean, our firm represents large corporate institutional employers, and then represents ma and pa type businesses. I think you see in the ma and pa type situation where everybody's busy trying to do what they got to do, trying to stay in business, trying to do a good job. Very little attention is being paid to human resource issues. So I think in that instance, I don't think there's an intentional effort to
But they've got to post notices, they've got to put things in the employee handbooks, and there's got to be some procedure if someone gets hurt on the job, aside from the fact they need medical attention right away, that there's got to be something that the employee knows to do after that injury that may help him along the path, and perhaps, Tony Vellner, sidestep litigation altogether.
Well, that's the plan. It doesn't generally happen that way. I mean, most people, when they get hurt at work, seem to be told, well, you got to go to this doctor, this outfit, go treat there and nowhere else. And typically, and unfortunately, I see so much that outfit, it's a physician's assistant, a nurse practitioner, go right back to work. It's just typically a lot of times they're pushed back to work so quick, so fast, that an injury that may have been a strain and sprain of the shoulder now becomes a cuff tear. And now they're out of work for 8 months versus a shorter period of time out of work. And that's the frustration I see from my new clients when they come in is, why am I being forced to do everything so quick, so fast? Why can't I just recover and then I'll be glad to get back to work? That's what I want to do anyway.
It's no accident either. But like what Tony said, it's no accident they go to a certain doctor, that the employer or the insurance company requires them, you have to go to this doctor. Now this doctor gets his business from the big employer, the big giant corporations that Andy represents, send all the injured workers to a certain doctor. He better tell that company what they want to hear. He better say, you could get right back to work. Because if he starts saying too often that, oh, wow, the guy's legitimately hurt, then they're going to find another doctor who's going to say what's going to save money. Because unfortunately, in our society today, it's dominated sometimes by bean counters. Somebody's in the back office with the little green eye shade saying, we need to save money on comp costs. So make sure you send them to Dr. So-and-so. He says everybody's okay. I mean, maybe I'm making it a little more sinister than reality. The judge is smiling. But sometimes I'm sure, the judge has to make that credibility determination. And sometimes you see the same doctors again and again and again, and they always say the same thing. In fact, they have word processed reports sometimes that I could just plug in, you plug in, you could see it. I have the same report from these doctors. It's unfortunate, and we deal with it all the time, but to an injured worker whose mortgage is on the line and whose supermarket bill is on the line, and they see a report like this that's word processed, that's going to destroy their life, that's major problem.
That's where the withdrawing into the foxholes occurs at that moment in time.
Yeah, I've never seen the mimeographed report. I've never seen a panel physician declare after the first examination that there is no problem here. As a matter of fact, I see just the opposite. Usually during the first few visits, the panel physician gives the injured worker every benefit of the doubt. Perhaps a panel doctor is more likely to declare an injured worker capable of returning to work more quickly than a claimant's own personal physician. And there's reasons why that may be the case. The situation that provokes an injured employee, maybe more significantly than any other, is not that the employee has to go to a panel physician necessarily, but it's when the employer shows no concern for the injured worker soon after the injury. If the employer would call the employee at home and say, how you feeling? Or if the employer were to call at the hospital, are you feeling okay? Or sending them a card or something like that. My experience has been that where the employer shows no concern, genuine emotional concern for a loyal employee, that's more than anything else pushes the employee to an attorney or to some form of litigation.
But you do counsel your clients to show interest for the injured worker. I mean, it's good business, let's face it. Even if you're talking about the bean counting and the bottom line, it's good business, but it also puts a humane face. It puts the humanity into the employer.
There's another factor that seems to be huge for most injured workers is, and it's out of their control, but it is a big factor in a workers' comp case, is who the comp carrier is. And in my practice and years of seeing it, self-insured employers seem to be on top of the list for worst as far as how they deal with a work injury. It's no different than if you perhaps self-insured yourself for a car, you rear-ended somebody and you complain about every bill that comes in versus you pass it over to your car insurance. That's how I see it and my clients see it. They don't realize that that's a big factor of the case.
In fact,
until
you know that it is a big factor. As soon as you see that the corporation is self-insured, you go, oh, we could be. They're going to fight very penny
or
here.
a claim or an NCP temporary, and it talks about third-party administrator. Certain big employers that I know are self-insured, it's going to be a struggle.
Tony's right. You're dead on correct with that. I would agree 100%. Another thing that I've noticed too is that this acrimony between employee and employer, once an injury happens, sometimes it even backfires on the employer, because there's a thing we talked about in other shows about subrogation. It's called. When you're hurt at work, sometimes the nature of the injury could give rise to a separate lawsuit against a third party. A machine manufacturer somehow amputated your hand, or something else blew up, or there was some other product manufacturer or some other third party that caused the problem. There could be a lawsuit. If the injured worker files a lawsuit, the employer or the insurance company gets their money back as part of it. So the employer should want to help that, should want to assist in any way possible to make sure they get their money back. Unfortunately, because of this anger sometimes that exists, not only do they not help, but they hurt. I've had cases where an employer will, I've had a couple of cases, unfortunately, where I think an employer made false statements about how the accident happened because they didn't want to look bad, that they didn't take proper precautions, even though it destroyed the third party case. That's another reason I think if a person's seriously injured at work, they should call a lawyer immediately, even if there's not a fight about the comp, because what if there's a third-party case? Evidence needs to be preserved, statements need to be taken, pictures need to be taken before the evidence is destroyed.
But then you know, of course, that the employer is going to get to his corner and crouch down.
Not always. You see,
not always?
If someone calls me and says, look, I got hurt really bad, or my father or my brother or somebody got hurt really bad, this is what happened, I go, wow, sounds like a third-party case. I can contact the employer and say, listen, I know you're going to be paying comp to this person for years, but you may get your money back because I think X, Y, and Z may apply. And then I could really help the client with a third-party case, a jury verdict, where you can get pain and suffering damages. And now we're looking at a win-win. The employer gets their money back, but you need to get that evidence right away, jump in there right after it happens.
Why do I think, though, that Andy's clients would still prefer that the worker not go out and get a lawyer? Because in the end, I
think Andy would agree with me. In a serious injury with the potential of third-party recovery, I'm happy when an Andy Greenberg is involved on the other side, because I have a voice of reason over there saying, whoa, help him, assist him, do what you need to do, supply the people to give statements. If he has a good case here, we get our money back. Where if you don't have an Andy Greenberg and you have a person with a narrow viewpoint saying, oh, I don't like that person, they're going to get money, they're going to try to sue somebody else, whoa, that's not helping at all.
Yeah. You know, the system is also helping, though, a little bit. When you think about mediation, under the system in Pennsylvania now, where we're having mandatory mediation and also voluntary mediation, the parties can come together and can voice many of these concerns that they've had off the record in a confidential manner, in which they can really spill their guts. And then this brings the people together, and they do reach a settlement. In many, many cases, more than ever are being settled.
And does it save the employer-employee relationship, whereas in the past, through litigation, that would be the end?
Right. One of the most difficult things that I have as a judge, for example, to actually have to adjudicate a decision in which it's the employee against the foreman. And if the question of credibility, and if the claim is going to go back to work at that employer, if I were to find that the employee is telling the truth and the foreman is not, they're not going to have a relationship. If I find it the other way around, they're not going to have a relationship either. In those kind of situations, mediation is very, very helpful. I always try, though, when there has to be an actual decision entered in that kind of a situation, to try to come to some other basis without having to determine that somebody is telling the truth and somebody isn't.
Tony?
Yeah, there's a lot of times when I'm preparing a client for testimony in front of a workers' compensation judge, like Judge Haken, that my client just has the story they want to tell the judge about their employer, and I have to, calm that down, come on. The judge needs to hear the facts, but there's a lot of times what happens to them at work as soon as they report the injury, the judge does need to hear, or what happened to them. But
Or at least let them blow off some steam so they can
Absolutely.
get to the facts.
And,
Ironically, the blowing off steam can hurt their credibility with the judge. In other words, a client comes to me and says, that foreman is no good, and he did this, and he said
In a
that.
courtroom, but not in a mediation session necessarily.
Well, as long as it's ex parte. What I mean by that for the viewers is when we're by ourselves with the judge. But when you're in front of a judge, and Judge Haken, I'm sure I think you would agree with this, if my client, the claimant, goes on and on about how rotten this guy was or that person was, it's not important. Don't go there. I sit down with my clients and I have to, like Tony said, you have to prepare them. This is what we need to talk about. This may be true, this may be important to you, but we don't go there. It's not necessary. You can only hurt yourself.
I think George makes a very good point, and that is that as attorneys, we have an obligation to keep our eye on the ball and to keep our client's eye on the ball. I had a situation involving a minor league baseball player who suffered an injury. He was contacted by the local press. The local press wanted to make a story about it, wanted the employee to criticize how management had handled the situation, and the attorney representing the injured baseball player cautioned the baseball player not to talk to the press, not to make this a public issue. In that instance, I felt that the attorney did the right thing by not making it personal, by not trying to embarrass the employer. So all of us have a certain responsibility, I think, both attorneys who represent employers and George and Tony who represent claimants, not to make it personal, not to antagonize the other side, not to besmirch the other side, but to simply focus on the issue, resolve or litigate the issue efficiently without embarrassing anybody.
That doesn't mean that I don't want to hear from my client all the dirt that they have to tell me. I want ammunition. I want to know if this guy, the foreman, did this or lied about that. I need to know everything. Tell me everything, but then I'll tell you how we want to present things. But give me the bullets. I may decide to fire somebody.
Right, but George isn't talking about taking a pot shot at somebody or taking a low blow. I don't think that's what George is talking about. He's talking about evidence that can impact upon credibility and can have a bearing upon either a favorable or unfavorable adjudication. We're not talking about cheap shots. I think that what I'm suggesting is that as attorneys representing clients, we all have an obligation to remove that tendency. Let's get rid of the cheap shots. Let's not deal with that kind of thing. Let's keep it above board. Let's deal with
Absolutely. There's a small bar that does workers' compensation, and the attorneys that would use the, quote, cheap shot are not well liked.
It's important for me to maintain a level of collegiality. With me and Andy and I, we may fight it out, but I respect him, he respects me. We're not going to take a cheap shot. Judge will know if somebody takes a cheap shot and it hurts us later. So I have to tell my client, don't get the wrong idea if I'm very friendly to the other side, because I am friends with them. That doesn't mean I'm not going to back you 1,000%.
And nowadays, of course, in the recent months, there have been a spate of cases that have come down from the United States Supreme Court, specifically dealing with things that go on in the workplace, and it's all about retaliation. And we're finding out that whether it's sex discrimination, gender discrimination, maybe there's a disability workers' comp issue, if someone is demoted or fired or somehow is compromised, even short of demoting or being fired, because they file a workers' compensation claim. Now, Judge, we're finding that the United States Supreme Court is squarely behind the plaintiff, the worker, the claimant in these kinds of matters. The corporation could get hit pretty hard if they take a retaliatory measure.
Right. You have to remember the workers' compensation required a constitutional amendment to enact the law. So the claimants have given up an awful lot in regard to this. They can't sue, they can't have a jury. And it's very important that the claimant be treated appropriately. And if there is retaliatory measures taken by the employer, subtly or otherwise, an action can ensue.
I actually brought the case with me. We talked about it before the show, Chris, that the issue is, can an employer terminate an employee just for filing a comp claim? And the landmark case in Pennsylvania is a case by the name of Schick versus Shirey. It's a Pennsylvania Supreme Court decision, and there's a little quote, that says the Act creates a duty in the employer to compensate employees for work-related injuries and a right in the employee to receive that compensation. But in order for the goals of the Workers' Compensation Act to be realized and for public policy to be effectuated, the employee must be able to exercise his right in an unfettered fashion without being subject to reprisal. If employers are permitted to penalize employees for filing workers' compensation claims, a most important public policy will be undermined. So the Supreme Court says, look, if you file a workers' comp claim and then you get fired for doing that, you can sue your employer where otherwise you couldn't do it. The devil is in the details in these cases, though, because believe me, a good lawyer like Andy, oh, we didn't fire him because filing a comp claim. We fired him because disciplinary problem, because his attendance record, because we didn't like the way he dressed, or so it always comes down to the facts. But the law is clearly on the side of the employee. You
All
can't
right,
fire
quickly,
somebody.
before we leave here, Tony, from a plaintiff claimant standpoint, what should an employee do to work with the employer but to safeguard his rights?
Best thing to do is, of course, give quick and clear notice to your employer of how you got hurt, what happened, who may have been there in the room with you when it happened, and to follow their procedures. Employers have certain procedures, fill out incident reports. You're going to have to maybe give us even a recorded statement to the workers' compensation insurance company. Follow those proceedings. Listen to your employer and do what you got to do, but also protect yourself by, if something hurts, let your employer and certainly the panel physician know what hurts, when does it hurt, and speak up as best you can.
And not expect the worst from the employer.
Correct.
And Andy, from your perspective, succinctly, what should the employer do?
Well, the employer, first of all, should show concern. Document the situation properly. If you're a self-insured entity, report it to your administrator immediately. If you're an insured entity, report it to your insurance company immediately. Make sure that the employee is afforded the care that he or she requires, and treat the person with dignity and respect. That's something I think all of us should expect.
Judge, last word for you.
Treat claimant the way you want to be treated, the same way, both sides. It's a biblical expression.
It works. Folks, we want to remind you that we are here every week, but if you need more information once we leave the air, it's easy. Go to our website, AmericanLawJournalTV.com, LawJournalTV.com. Every program that we broadcast here later goes up to the website as a webcast. If you need more information, call us toll free, 888-78-LAW-TV. Write to us at info@lawjournaltv.com. Go to the website, get your law on demand. I want to thank my claimants attorneys, George Beatty from Beatty, Sloan and DeGeneva, Tony Vellner from the Vellner Law Offices in Eastern Pennsylvania, Andy Greenberg with Chartwell representing the corporations in comp matters, and the Honorable Joseph Haken. Thanks. Check us out right here on Comcast next week. For all of us here at the program, thanks a lot. We'll see you now.
Tonight's American Law Journal has been made possible in part by Beatty, Sloan, and DeGenova. Decades of experience providing personal attention to those injured at work or suffering from serious injury due to medical malpractice, defective products, motor vehicle accidents, and other causes, with offices in Philadelphia and Haddonfield, New Jersey. The Chartwell Law Offices, representing insurance companies, self-insured entities, third-party administrators, and other business concerns in general liability and workers' comp matters. Philadelphia, Pittsburgh, Harrisburg, Scranton, and Valley Forge. The law offices of Anthony Vellner, a firm devoted to representing individuals injured on the job who are entitled to a reasonable, necessary, and related medical expense and compensation, and serving those who have been denied Social Security disability benefits, Bethlehem. And the legal and Intelligencer, the nation's oldest legal newspaper for lawyers.